The idea is that these LLMs have been trained on data sets that allegedly include pirated book collections, that include thousands, tens of thousands of titles obtained without permission.
I think that there's three major issues that these cases set forth. Number one is, does just the mere training of a large language model with copyrighted material itself an act of infringement? And does then that trained model itself infringe as, say, a derivative work of the copyrighted works? Then the second question is, if a user of a large language model that has been trained with copyrighted works produces something that's very similar to those copyrighted works, is the user also on the hook for infringement, again, potentially as a derivative work? The third issue, and perhaps the most difficult issue to address in these situations, is the whole concept of fair use. And the thing is, the fair use analysis is very fact sensitive. And we don't have the facts here yet. These cases haven't gone to discovery yet. And it may take years for courts to put together a patchwork of cases before we get a sense of what the contour of the fair use issue with AI really is.
The writers are going to face an uphill battle because they're going to not only need to prove unauthorized copying, but also the production of unauthorized, large amounts of the unauthorized works as well.
How can there not be copyright infringement when somebody asked for instance, something in the style of Taylor Swift, a song in its style of Taylor Swift? It seems to me like whatever server's out there has got to have Taylor Swift's songbook portfolio, figure out what that is, what style that is, do something equivalent to it, and is obviously doing this for a purely commercial purpose, or else there'd be no reason to supply AI services to anybody.
Just by training a model on copyrighted material, is that in and of itself an act of infringement? Now, in the Google Books case, which is somewhat analogous, the answer so far has been no. So let's try to keep it simple. Let's say that we're just feeding a large language model like ChatGPT Taylor Swift lyrics. So there is a copy that would go into the model, but then the model is going to process those words, turn them into numbers, essentially a large number of mathematical equations and parameters. And so what the model is actually going to store when it's generating is not going to be the actual lyrics. It's going to be storing a much more abstract representation of that, as well as everything else it was trained on. So the first issue to keep in mind as you're grappling with who owns the output of AI models is the fact that the copyright law only protects works of human creativity. And so if you have a situation where the model is creating something in and of itself with minimal or no human input or creativity, that's clearly not copyrightable. And at the very least, the Copyright Office has taken that position so far. But then where things get more interesting is when you take the output of an AI model and then a human modifies it in some fashion, whether that means incorporating it into a larger work of human creativity or perhaps modifying it in some fashions. So you can think of it as being on a sliding scale where if there's no human input or minimal human input, the work is probably not copyrightable. And the more human input and creativity that goes into it, the more copyrightable it is.
Yeah, I completely agree with Mike. I mean, when you're looking at generative AI, whether it's in the imagery space or LLMs, the devil's going to be in the details. You can use a freeware version of an LLM, but things like confidentiality, things like the ability to use your prompts and outputs as training data for future iterations of the model, those are generally not in your hands. Whereas in the pay versions of these software, you can have a little bit more control over these details, and it's important that interested parties take a close look at those licenses.